Good evening, everyone. Thanks for joining us for the monthly labor law update for the month of in this month's update. To start with, the Tamil Nadu government has brought about two amendments to the One is to the Tamil Nadu Labour Welfare Fund Amendment Act, by which the annual contribution to be made to the Labour Welfare Fund has sought to be enhanced. Every employee is now required to contribute 50 rupees and employers up to 100 rupees, and the state government is going to be contributing rupees 50. And the other amendment under the Shops Act, there are two amendments under the Shops Act. One requires all establishments, specifically meant for shops, to ensure that they have seating facility for their employees. So proper seating facilities must be provided. The second amendment is an amendment to the 2018 Amendment Act. There was an Amendment Act in 2018 bringing about registration of shops and establishments under the Tamil Nadu Act. In that, they have brought in an amendment to say that within 24 hours, you should be issued with a certificate, failing which it's an automatic deemed registration of the establishment. So these two amendments have been brought by the Tamil Nadu government to the Tamil Nadu Shops and Establishments Act. A very interesting circular or guidelines by notification by the government of Bengal. This is under the Payment of Bonus Act. It's not clear under what provision they issued it, but where the government has requested employers more, I think, to do with the corona and the past years, how things have been, to have a flexible attitude in payment of bonus. They in fact also want ex gratia to be paid. So whether the employment is casual or it's a re-employment, or including even contract workers, they want bonus to be ensured to be paid and before the Durga Puja starts. And they've also further said that even if there be any default in the previous years, employer should ensure that the same is complied during this period. The notification, though issued under the Payment of Bonus Act, has also gone further to say even the bonus should be extended to unorganized sector as well, and ineligible employees. It's quite interesting notification from the government. The Provident Fund organization has streamlined the process or given guidelines as to why, because there are a lot of issues with your Aadhaar seeding. There are requirements as to the date of birth or the name not matching and how you need to change it online. What is the guidelines to be done to make changes to members' data in the EPFO website has been given by this notification. Of course, they've also made it clear that if there's going to be a change in the name itself, so if an employee changes his name, then that's a different process. It is not online, and that needs to go offline and the appropriate Gazette notification, and things have to be checked before it is done. There was a mandate that by 1st of September 2021, the Aadhaar seeding has to be completed. Now the date has been moved to 31st of December. Apparently, the Delhi High Court has also granted a stay in this regard. But the more interesting aspect which needs to be taken is if there be any default in the months of August or September 21 due to non-seeding of Aadhaar, no damages will be levied. So that is a relaxation that the Provident Fund organization has given. Under the ESA Act, the provisions of the ESA Act are now being extended by the government of Manipur to various establishments like shops, hotels, restaurants, newspaper establishment, even medical institutions, and municipal corporations and bodies. It is quite interesting to see that they're extending ESA to municipal corporations and municipal councils. It's a very not found in many other states. So this is an establishment in Manipur. They are extended the ESA provisions. Coming to our quiz corner, the question is, Under the Industrial Relations Code 2020, the model standing orders can be published by whom? Is it the central government, the state government, appropriate government, or both the central and the state government? Do post your answers in the chat box. We shall reveal the answer at the end of the session. A new initiative by the Provident Fund organization, especially for retired employees. So any employee who is due to retire 1 month prior to the retirement itself, he could give a form, and it will be ensured that on the date of his retirement itself, his pension would be sanctioned. So it's a way forward in the Provident Fund organization. They've been extremely proactive in many things, and this is another step taken by the Provident Fund organization in this regard. We've already seen this Uber taxi drivers, what is going to happen with them. UK courts have already said that they are also employees. There was a liability to pay overtime. Now it's a term of a Dutch court to also take a very similar view. We need to, of course, see this in context with our social security code that we propose to bring in for gig workers. So these kind of workers are sought to be covered as gig workers under the social security code. But if they are to be treated as regular employees, like what has been held by the British courts or this court by the Amsterdam court, it would be an interesting turn whether this concept of gig workers that India is trying to promote, but whereas the other countries are looking at them as permanent employees. This is what we thought was going to be our topic this time for domestic inquiry and evidence for this month's Knowledge Corner. Why do we take it is, of course, because of a judgment that has come out recently. Normally, any evidence that has to be adduced, it has to be in compliance with the requirements of the Indian Evidence Act 1872. This act specifically says what can be given as evidence, who can give it, what is the manner in which evidence has to be adduced, and what can be adduced and what cannot be adduced. So it's a whole gambit of things that are being covered under the Indian Evidence Act 1872. And under this act, if you look at it, there are two types of tests for an evidence to be adduced. For instance, if you look at a criminal court, the manner in which it has to analyze an evidence is that it should be beyond any reasonable doubt. So if a court is to hold any person guilty of an offense, it would need to be 100% sure, yes, this person is done. And the test is normally in the legal parlance called as beyond reasonable doubt. Whereas if you look at other civil proceedings, it's just a preponderance of probability. Yes, based on this is what could be done, and it is not beyond reasonable doubt that needs to be done. So when it comes to domestic inquiry, it has also been held that the test is not beyond reasonable doubt, but it's only preponderance of probability that needs to be done. One of the early cases of the Supreme Court is in the state of Haryana versus Ratan Singh, pertaining to a conductor who did not issue tickets after collecting money from passengers, and what kind of evidence can be adduced, and where for the first time Supreme Court says even hearsay evidence can be adduced, which is prohibited under the Indian Evidence Act. Statements of the passengers were taken in the inquiry without the passengers themselves being examined. As late as 2008, the Supreme Court has once again reiterated in the Balmadi's estate case the same principles, including the fact that the Evidence Act is not strictly applicable to a domestic inquiry, and it is not that you need to stretch it to an extent of what a criminal court does. It's not even to the extent of what a civil court would require, is what later on they have clarified in certain cases. So in this, these are certain other judgments of the Supreme Court where they have said that the strict rules of evidence would not be applicable in domestic inquiry, and also to the effect that preponderance of probability is the test to be applied and not anything else. Well, recently, we had an occasion to place a case before the Madras High Court on whether a CCTV evidence could be adduced, and the question was pertaining to because of the electronic evidence, what is the nature of it, whether it could be done. Again, applying the same principles of Evidence Act, you don't need to follow the strict provisions even in respect of marking electronic evidence in a domestic inquiry is what the High Court has held. So this is an area where it is evolving, because we will be using more and more of electronic evidence as we go by, and even that evidence can be admitted not with a very strict rules, but the principle is to be followed. That is, principle of natural justice should be there, and there should be a reasonableness in what is to be done, is what courts have held. So this is our knowledge corner for this month on evidence in domestic inquiry. Next week, we will also try to, next month, we'll try to do more on domestic inquiries as we go forward. Under the ID Act, if you were to retrench an employee and you were to recruit anybody within a period of 2 years, then you need to give preference to a retrenched employee. Under the IR code, this stands reduced to 1 year. Similarly, under the Factories Act, an employee, if he's to be eligible for earned leave, he should have worked for 240 days. But under the OSH code, it is only 180 days. So if an employee works for 180 days, he gets entitled or eligible for earned leave. Of course, the number of days of leave will be linked to the number of working days, but his entitlement or eligibility for the leave itself stands reduced to 180 days. This is the latest one, where on COVID deaths, the government has said that the state governments would be giving 50,000 rupees as compensation to each of the dead persons. Is there a latest update on that? This is a case of a Supreme Court on daily wages. What happens with the daily wage employee? This employee had worked for a long number of years, but he had not put in 240 days in any year. The question more was whether who has to prove it. The Supreme Court once again has reiterated that it is the employee who has to prove that he has put in 240 days, but has in this case granted a hefty compensation of 8 lakhs to the employee. The question as to whether NEEM trainees would need to be covered under the PF Act has been lingering for quite some time. One writ petition has been filed by an employer challenging an order passed under Section 7A, directing the employer to pay NEEM, Provident Fund contribution to NEEM trainees. The High Court has felt that there's a prima facie case and granted stay of the order passed by the Regional Provident Fund Commissioner. We shall keep you updated on progress on this as we go by. This is your complaints calendar for this month. So coming back to the question on the quiz, which is the appropriate government, the answer is central government. State governments are not any longer empowered to publish their own model standing orders under the new code. It's only the central government alone which has been given this power. So that brings us to the end of this month's update. Thanks for joining us. Hope to see you all on 30th October at 4 p.m. Thank you.